Hi friends, I am Professor Kshitij Bansal. I teach law at Jindal Global Law School. The module that we are going to discuss today is International Law and the Protection of Farmers' Rights, Convention on Biological Diversity. What are the learning outcomes from this module? This module will introduce you to the interaction between the rights of farmers, rights of the breeders, and the provisions of Convention on Biodiversity. You would then be taken through the details of Convention on Biodiversity, CBD for our reference, and its provisions which regulate farmers' rights like benefit sharing. Let us begin with the introduction. The Convention on Biological Diversity is mainly a document aimed at protecting the environment by maintaining the diversity of it. However, this convention is of significance to farmers because in order to maintain this diversity, scientists and breeders are allowed to have access to plant genetic resources, PGR for our reference, which will be used by them to develop new plant varieties. Thus, in turn, will be a subject matter of plant breeders' rights. This is also applicable to plant genetic resources for food and agriculture. It is at this juncture that the farmer's rights is attracted, otherwise CBD applies to all types of PGR. So, unless in the CBD there is enough space for farmers' rights, plant breeders' access to PGR of the farmers will be easy and vice versa will be very tough. Also, due to this reason, there is a need to recognize property rights to the farmers also in this document. The objective of this chapter is to find out whether CBD gives any right to the farmers as against plant breeders' rights. The Convention on Biological Diversity, being an international convention, recognizes the states as the authority to determine access and other rights over PGR, plant genetic resources. Convention on Biological Diversity, that is CBD, says recognizing the sovereign rights of the states over their natural resources, the authority to determine access to genetic resources rests with the national governments and is subject to national legislation. This shows that the rights of the holders of PGR is to be recognized, rather can be by the states concerned. This is a space left by CBD for the domestic legislations to give their local people or indigenous people or farmers any rights that they require. However, one article in the convention directly speaks about two concepts, not rights, which could be solidified into right by the state parties through their local legislations. The two concepts recognized are from Article 8, Clause J, which says each contracting party shall, as far as possible and as appropriate, subject to its national legislation, respect, preserve and maintain knowledge, innovations and practices of indigenous and local communities, embodying traditional lifestyles relevant for the conservation and sustainable use of biological diversity, and promote their wider application with the approval and involvement of the holders of such knowledge, innovations and practices, and encourage the equitable sharing of the benefits arising from the utilization of such knowledge, innovations and practices. From this, it is quite clear that there are two potential rights called approval and involvement of the holders of knowledge, innovations and practices, equitable sharing of benefits. But these are only potential rights because these are subject to national legislations. However, these words give space for recognition of two rights which otherwise the states would not have been able to recognize. From the wording of Article 8, Clause J, which I just read out to you, it is quite clear that these are group rights due to the words indigenous and local communities and stakeholders. Now let us see the implications of these two concepts. First, approval and involvement of the holders. Approval and involvement of the farmers are more clearly used as prior informed consent, PIC for our reference, in another provision of CBT. These provisions are recognizing the sovereign rights of states over their natural resources. The authority to determine access to genetic resources rests with the national governments and is subject to national legislation. Secondly, each contracting party shall endeavor to create renditions to facilitate access to genetic resources for environmentally sound uses by other contracting parties, and not to impose restrictions that run counter to the objectives of this convention. For the purposes of this convention, the genetic resources being provided by a contracting party as referred to in this article and Article 16, which talk about access to and transfer of technology, and 19, which talks about handling of biotechnology and equitable sharing of benefits, are only those that are provided by contracting parties that are countries of origin of such resources, or by the parties that have acquired the genetic resources in accordance with this convention. Access, where granted, shall be on mutually agreed terms and subject to the provisions of this article. Fifth, access to genetic resources shall be subject to prior informed consent of the contracting party providing such resources, unless otherwise determined by that party. Though state is the ultimate authority to decide on the prior informed consent, as it is not the farmers whose prior informed consent that is envisaged by the CBD, if the state parties choose to allow access to genetic resources which are held by the farmers, then the PIC is and should not be that of the state, but that of the farmers, as justice and fairness demands it. Thus, the PIC of the farmers becomes inevitable in the case of allowing access to plant genetic resources and farmers' access. CBD does not give any guideline on either PIC or benefit sharing. There are some guidelines, however, by the Secretariat of the Convention of Biological Diversity, the study by the TRIPS Council on the relationship between TRIPS and CBD at the WTO, case studies in countries like Panama, Philippines and Russian Federation, and the latest Nagoya Protocol of CBD on access and benefit sharing. Actually, there was no need of such rights in the past, as there was no economic value and thus no demand for plant genetic resources and traditional knowledge. In the changed circumstances, prior informed consent is recognized lest the PGR and traditional knowledge of the farmers should be looted away. So, prior informed consent can be said to be a product of necessity of the time. It means that the law recognizes that the farmers are the ultimate authority to decide on plant genetic resources and the traditional knowledge held by them. Actually, identifying them as the custodians of traditional knowledge and plant genetic resource itself is a recognition of some rights to them, as otherwise it is not definite as to who all hold that. So, the depth and breadth and effectiveness of this right, which is right to be consulted, depends on the national legislation. However, there is an international understanding about this aspect which should be reflected in the national legislations, including that of India. So, brief description about this international understanding is done here. Article 8 Clause J stipulates that the above discussed wider application of the knowledge, innovations and practices of the indigenous and local people with traditional lifestyle should be done with the approval and involvement of the holders of such knowledge, innovations and practices. Reading these two provisions together gives the picture that not only the approval, prior informed consent in other words, but also the involvement of the farmers will be needed while allowing access to plant genetic resources. However, this interpretation needs to be tested in the light of other guidelines issued by the Secretariat of the CBD and the more binding instrument, the Nagoya Protocol on Access and Benefit Sharing to CBD. Nagoya stipulates the following principles: providing for legal certainty, clarity and transparency of their domestic access and benefit sharing legislation or regulatory requirements. Second, providing for fair and non-arbitrary rules and procedures on accessing genetic resources. Third, providing information on how to apply for prior informed consent. Fourth, providing for a clear and transparent written decision by a competent national authority in a cost-effective manner and within a reasonable period of time. Fifth, providing for the issuance at the time of access of a permit or its equivalent as evidence of the decision to grant prior informed consent and of the establishment of mutually agreed terms, and notify the access and benefit sharing clearinghouse accordingly. Sixth, where applicable and subject to domestic legislation, setting out the criteria and or processes for obtaining prior informed consent or approval and involvement of indigenous and local communities for access to genetic resources. And last, establishing clear rules and procedures for requiring and establishing mutually agreed terms. Such terms shall be set out in writing and may include, inter alia, a dispute settlement clause, terms on benefit sharing, including in relation to intellectual property rights, terms on subsequent third-party use, if there's any, and terms on change of intent wherever applicable. One of the principles of prior informed consent is prior informed consent should be obtained from national competent authorities in the case of access genetic material preserved in situ. What is the role of the traditional farmers here is the question. Nagoya Protocol stipulates that respecting established legal rights of indigenous and local communities associated with the genetic resources being accessed or where traditional knowledge associated with these genetic resources is being accessed, the prior informed consent of indigenous and local communities and the approval and involvement of the holders of traditional knowledge, innovations and practices should be obtained in accordance with their traditional practices, national access policies, and subject to domestic laws. This suggests that if there are established legal rights for farmers over plant genetic resources or traditional knowledge, they will have to be respected while access is being given to them by that respective state. This gives the scope to the national legislations to create even property rights to the farmers over PGR and traditional knowledge as envisaged in CBD. Let us now talk about benefit sharing. Benefit sharing is another potential right that stems from CBD. When the plant breeders develop a new variety of the traditional varieties that are conserved by the farmers over generations and through traditional practices, the new variety gets protection as a plant breeder's right and is of high economic value. But the farmers who conserve the traditional varieties over a number of generations do not get anything out of this. So the benefit sharing concept demands that the farmers in CBD, the word used is local community and indigenous people, should be given a share of the benefit that is accrued to anyone by the usage of the traditional knowledge or plant genetic resource that is maintained by those farmers. In CBD, it is provided for in Article 19, which says, each contracting party shall take all practicable measures to promote and advance priority access on a fair and equitable basis by contracting parties, especially developing countries, to the results and benefits arising from biotechnologies based upon genetic resources provided by those contracting parties. Such an access shall be on mutually agreed terms. Nagoya Protocol also deals with benefit sharing, and it says, in accordance with Article 15, paragraphs 3 and 7 of the Convention, benefits arising from the utilization of genetic resources as well as subsequent applications and commercialization shall be shared in a fair and equitable way with the party providing such resources, that is, the country of origin of such resources or a party that has acquired the genetic resources in accordance with the Convention. Such sharing shall be upon mutually agreed terms. Second, each party shall take legislative, administrative or policy measures as appropriate with the aim of ensuring that benefits arising from the utilization of genetic resources that are held by indigenous and local communities in accordance with relevant domestic legislations regarding the established rights of these indigenous and local communities within that state over these genetic resources, and that they are shared in a fair and equitable way with the communities concerned based on mutually agreed terms. Nagoya Protocol further talks about implementing paragraph 1 mentioned above. Each party shall take legislative, administrative or policy measures as appropriate to implement that paragraph. Fourthly, benefits may include monetary and non-monetary benefits, including but not limited to those listed in the annex to Nagoya Protocol. Fifth, each party shall take legislative, administrative or policy measures as appropriate in order that the benefits arising from the utilization of traditional knowledge associated with genetic resources are shared in a fair and equitable way with indigenous and local communities holding such knowledge. Such sharing shall be upon mutually agreed terms. This is Nagoya Protocol Article 5. Nagoya Protocol envisages a clearinghouse for the purpose of access and benefit sharing. The provision provides that an access and benefit sharing clearinghouse is hereby established as a part of the clearinghouse mechanism under Article 18, paragraph 3 of the Convention. It shall serve as a means for sharing of information related to access and benefit sharing. In particular, it shall provide access to information made available by each party relevant to the implementation of this protocol. Without prejudice to the protection of confidential information, each party shall make available to the access and benefit sharing clearinghouse any information required by this protocol as well as information required pursuant to the decisions taken by the conference of parties serving as the meeting of the parties to this protocol. The information shall include legislative, administrative and policy measures on access and benefit sharing, information on the national focal point and competent national authority or authorities, and third, permits or their equivalents issued at the time of access as evidence of the decision to grant prior informed consent and of the establishment of mutually agreed terms. Additional information, if available and as appropriate, may include relevant competent authority of indigenous and local communities and information as so decided, model contractual clauses, methods and tools developed to monitor genetic resources, and codes for the conduct and the best practices. The modalities of the operation of the access and benefit sharing clearinghouse, including reports on its activities, shall be considered and decided upon by the conference of the parties of CBD, serving as the meeting of the parties to this protocol as well at its first meeting and kept under review thereafter. This is Article 15 of CBD. It would be fair enough to conclude that one of the main problems with sharing of benefits regarding country of origin or countries of origin and the indigenous and local communities is that to fix the country of origin or the particular indigenous or local communities within that country who hold a particular plant genetic resource or traditional knowledge, and this is very difficult. Even if a particular community is recognized as the holders of a particular plant genetic resource or traditional knowledge, it is still a question as to how the benefit should be utilized. To whom, what percentage? Actually, being a group right, these two concepts called the prior informed consent and the equitable sharing of benefits cannot be of any practical relevance unless there are clear methods for creating these two concepts as group rights and thus the realization of it. I hope this was interesting for you. Thank you so much for listening.